Hey everyone, so this is going to be a long video. It's going to be the documents that I just got that we are kind of concerned about Stepan's rights being violated. The documents you're going to see here are watermarked. If you would like these documents for yourself without the watermarks to do with whatever you please, you can find them on my Patreon, which will be linked below. This is going to be a long video because there's a 26-page document, a 22-page document, and this first document is 14 pages. So I'm going to go ahead and get started. This first document is obviously the state of Florida as a plaintiff versus Stephen Michael Stearns, the defendant. It is a motion to suppress evidence obtained from unlawful seizure of cell phone. It reads, comes now the defendant, Stephen Michael Stearns, by and through his undersigned counsel, pursuant to the Fourth Amendment to the United States Constitution, Article 1, Section 12 of the Florida Constitution, and the Florida Rule of Criminal Procedure 3.190, subsection G, and hereby moves this honorable court to suppress all evidence obtained directly and indirectly from law enforcement's unlawful seizure of his cell phone. As grounds for this motion, the defendant states, Introduction. This case presents a flagrant violation of Mr. Stearns' constitutional rights under the Fourth Amendment, Article 1, Section 12 of the Florida Constitution. Detective Tangler with Orange County Sheriff's Office ultimately seized Mr. Stearns' cell phone without consent, without a warrant, and without exigent circumstances. The phone was then retained for over 9.5 hours before law enforcement coerced a purported, quote, consent, unquote, for its forensic examination. Because the seizure was unlawful and all evidence obtained bears the taint of this initial illegality, the court should suppress the cell phone evidence and all derivative fruits. This motion is filed contemporaneously with related motions to suppress evidence obtained from the unlawful search of Mr. Stearns' phone and evidence obtained through the subsequent Google account warrant that relied on the fruits of this unconstitutional seizure. Evidence to be suppressed. Any and all tangible evidence obtained contemporaneous to and following the illegal seizure of Stephen Michael Stearns' cell phone, specifically including but not limited to all data obtained from the subsequent download of the phone, all evidence obtained through execution of the Google warrant, and all derivative evidence and investigative leads developed through exploitation of these constitutional violations. Standing. Stephen Michael Stearns has standing under the Fourth Amendment to the United States Constitution and Article 1, Section 12 of the Florida Constitution, as he was the owner and possessor of the cell phone that was illegally seized on February 27 through 28, 2024. Riley v. California establishes that cell phones are entitled to heightened Fourth Amendment protection due to the vast amount of private information they contain. They cite Riley v. California from 2014. Burden on the moving party. The moving party's initial burden has been met through documented evidence of a warrantless seizure in law enforcement reports. Once established that a seizure occurred without a warrant, the burden shifts to the state to prove an exception applies. They cite Norman versus State from 1980. While I flip this page, if you guys want to see us talking about these documents and basically stating what we thought about it, you can do so in the live stream with this thumbnail. Statement of facts. 1. On February 26, 2024, at approximately 2000 hours, Jennifer Soto reported her 13-year-old daughter, Madeline Soto, missing to the Orange County Sheriff's Office. 2. On February 27th, Detective Francis Hunt identified inconsistencies in statements provided by Ms. Soto and Mr. Stearns. 3. Detective Tangler of the Orange County Sheriff's Office was assigned as lead investigator. 4. On February 27, 2024, at approximately 1600 hours, Detective Tangler, accompanied by Detective Acosta, contacted Mr. Stearns at his residence. 5. The detective's interactions with Mr. Stearns were audio recorded and captured the exchanges between law enforcement and Mr. Stearns. 6. Mr. Stearns' residence is located at the address. 7. Detective Tangler sought limited access to Mr. Stearns' cell phone, specifically requesting only to check his Google login status by asking, quote, is it okay if I go in your settings real quick? I just want to see if you're logged onto your Google, unquote. 8. Mr. Stearns responded, quote, yeah, unquote, to this specific and limited request. 9. After exceeding the scope of this limited consent, Detective Tangler unilaterally announced, quote, I'm going to hold on to your phone, unquote, and quote, I'll give it back to you when we're done, unquote. 10. Mr. Stearns expressed explicit concern about maintaining contact with his father through that phone. 11. Detective Tangler dismissed Mr. Stearns' concerns by stating they could call Ms. Soto's phone instead. 12. Mr. Stearns was given no choice regarding the seizure of his phone. 13. No consent was sought for the seizure of the phone. 14. Law enforcement made no attempt to obtain a search warrant for the phone despite having ample time to do so. 15. The detectives did not present Mr. Stearns with a written consent form for the seizure. 16. The detectives did not advise Mr. Stearns of his right to refuse consent. 17. The detectives did not provide Mr. Stearns with any documentation regarding the seizure of his phone. 18. The detectives did not document any exigent circumstances justifying the warrantless seizure. 19. On February 28, 2024, at approximately 1:30, detectives again contacted Mr. Stearns. 20. The second contact occurred approximately 9 hours and 30 minutes after initial seizure of his phone. 21. During this midnight contact, detectives referenced their earlier unauthorized seizure, stating, quote, "I told you that I was going to hold on to it and that we would like to download your phone, right?" Unquote. 22. The detectives presented Mr. Stearns with an ultimatum, quote, "Is this something I have your consent to do, or do I need to get a search warrant for your phone?" Unquote. 23. At the time of this midnight interaction, Mr. Stearns had been detained outside in 50 to 60 degree temperatures. 24. Mr. Stearns was wearing only flip-flops, khaki pants, and a thin hoodie. 25. Mr. Stearns had not eaten all day prior to the incident. 26. Mr. Stearns was not allowed to return to Ms. Soto's vehicle, which was heated despite cold weather conditions. 27. Earlier that night, Mr. Stearns had taken an Ativan, a prescription medication to manage his panic attacks. 28. Mr. Stearns clarified to authorities that he had taken the tranquilizers to help him sleep, as he had been struggling with insomnia. 29. Ativan is a prescription sedative commonly used to treat anxiety and panic disorders. 30. Ativan is known to cause drowsiness and sedation and impaired alertness. 31. Mr. Stearns described the effects of Ativan to law enforcement, stating, quote, "This is why I missed your calls. I'm sorry. Took an Ativan and conked out for a few hours." Unquote. 32. At approximately 2:40 on February 28, 2024, Mr. Stearns' phone was taken to the Orange County Sheriff's Office Digital Forensic Unit. Legal argument. A. The warrantless seizure of Mr. Stearns' cell phone was unconstitutional. The Fourth Amendment protects against unreasonable seizures of property, even when no search has taken place. United States v. Place from 1983 is what they state. A, quote, "seizure," unquote, of property occurs when there is some meaningful interference with an individual's possessory interest in that property. They cite United States v. Jackson from 1984. The instant matter presents precisely such a meaningful interference as Detective Tangler unilaterally seized and retained Mr. Stearns' cell phone for over 9 hours without consent or probable cause. The Florida Supreme Court has consistently held that Article 1, Section 12 of the Florida Constitution is coextensive with Fourth Amendment jurisprudence. They cite State v. Hernandez from 1998. While law enforcement may temporarily seize property to prevent destruction of evidence while seeking a warrant, such seizures must be, quote, "properly limited in scope," unquote. They cite Place. The United States Supreme Court has emphasized that courts must consider, quote, "the length of the detention," unquote, in determining whether a seizure is reasonable. The Supreme Court held in Place that even when supported by reasonable suspicion, a 90-minute detention of property was unreasonable. Here, the 9.5-hour seizure, unsupported by any reasonable suspicion, grossly exceeded the temporal limits deemed reasonable in Place. The Florida Supreme Court analysis in Golphin v. State further illuminates why the seizure here was unconstitutional. Golphin v. State from 2006, what they cite. In Golphin, the court examined whether retention of identification during a brief warrants check constituted a seizure, emphasizing that, quote, "not all encounters between law enforcement and individual citizens constitute seizures," unquote. but rather courts must examine the totality of circumstances to determine if there was meaningful interference with possessory interest. Unlike Golphin, where officers merely retained identification briefly during a consensual encounter, Detective Tangler effected a full seizure by unilaterally announcing that she was taking possession of the phone without seeking consent, retaining it for over 9 hours, and completely depriving Mr. Stearns of his ability to communicate with family members. The extended duration and complete deprivation of Mr. Stearns' possessory interest in his phone demonstrates why this case falls squarely within Place's holding that even brief investigative detentions of property must be properly limited in scope and duration. Detective Tangler made no attempt to obtain a warrant despite the availability of an emergency duty judge system and ample time to do so during the initial seizure. Instead, Detective Tangler retained the phone for over 9.5 hours without providing any indication of when or how it would be returned, far exceeding any reasonable scope or duration under Fourth Amendment jurisprudence. The length in detention alone precludes any argument that this was a properly limited investigative detention under Place and its progeny. 1. The initial seizure exceeded the scope of any purported consent. While consent provides an exception to the Fourth Amendment's warrant requirement, such consent is strictly circumscribed by its express scope and circumstances. They cite Florida versus Gimeno from 1991. The United States Supreme Court has established that the standard for measuring scope of consent is one of objective reasonableness. Specifically, quote, what would the typical reasonable person have understood by the exchange between the officer and the suspect, unquote. This objective standard protects against law enforcement's unilateral expansion of narrowly granted permissions into broad investigative authority. Florida courts have consistently enforced strict limitations on the scope of consent, recognizing that permissions granted for one limited purpose cannot justify broader government intrusion. In Appellate versus State, the 5th District Court of Appeal held that consent to enter a home to check on well-being did not authorize a full search of the premises. And Appellate versus State from 2015 is what they cite. Similarly, in State versus Wells, the Florida Supreme Court determined that consent to search a car trunk did not extend to closed containers within that trunk. And they cite State versus Wells from 1989. The decisions reflect the bedrock principle that law enforcement may not exceed the reasonable scope of specifically granted consent. In this instant case, Mr. Stearns provided extremely limited consent for Detective Tangler to, quote, go in your settings real quick, unquote, solely to, quote, see if you're logged onto your Google, unquote. No reasonable person would understand this narrow permission to check a single phone setting as consent to a complete seizure and 9.5-hour retention of this device. Detective Tangler's unilateral announcement that she was, quote, going to hold onto your phone, unquote, and subsequent extended seizure far exceeded any reasonable interpretation of Mr. Stearns' limited consent. This expansion of authority mirrors the impermissible scope extensions rejected in both Appellate and Wells. Just as consent to look in a trunk does not permit searching closed containers, permission to check a single phone setting cannot justify a prolonged seizure of the entire device. The unreasonableness of interpreting such limited consent to authorize extended seizure is particularly apparent given the Supreme Court's emphasis in Place that even brief investigative detentions of personal property must be strictly limited in scope and duration. They cite Place again. When Detective Tangler exceeded the bounds of consent by unilaterally seizing the phone, she needed independent constitutional justification for that expanded intrusion. No such justification existed, rendering the extended seizure unconstitutional under both consent and general Fourth Amendment principles. Number 2, no exigent circumstances justified the extended seizure. While law enforcement may conduct a warrantless seizure when exigent circumstances exist, such circumstances are, quote, few in number and carefully delineated, unquote. They cite Welsh versus Wisconsin from 1984. The state bears the burden of demonstrating that the procurement of a warrant was not feasible because, quote, the exigencies of the situations made that course imperative, unquote. They cite Coolidge versus New Hampshire from 1971. None of the recognized exigent circumstances existed here. First, there was no, quote, hot pursuit, quote, of a fleeing suspect that would justify the warrantless seizure. See United States versus Santana from 1976. Mr. Stearns was at his residence and fully cooperative with law enforcement when Detective Tangler seized his phone. He made no attempt to flee or evade the officers. Second, there was no imminent destruction of evidence. See Kentucky versus King. They cite Kentucky versus King from 2011. Detective Tangler articulated no specific facts suggesting Mr. Stearns was attempting to or about to delete data from his phone. Indeed, the phone had already been factory reset prior to the seizure, undermining any claim that immediate warrantless seizure was necessary to prevent the destruction of evidence. The mere possibility that additional evidence could be deleted is insufficient to create exigency, as this would effectively eliminate the warrant requirement for all cell phones. They cite Riley versus California from 2014. Whereas here, any purported destruction of evidence had already occurred. Law enforcement cannot justify a warrantless seizure based on preventing what has already happened. Third, no emergency aid circumstances existed. They cite Brigham City versus Stewart from 2006. The state will likely argue that the missing child investigation created emergency circumstances justifying the warrantless seizure under the emergency aid doctrine. And they cite again Brigham City versus Stewart from 2006. This argument fails. The emergency aid exception requires law enforcement to have an objectively reasonable bias to believe that an emergency exists, requiring immediate action to prevent imminent harm. They cite Missouri versus McNeely from 2013. While the underlying missing person investigation was undoubtedly serious, the circumstances here do not justify a 9.5-hour warrantless seizure. The timeline itself negates any claim of emergency requiring immediate warrantless action. The child was reported missing at 2000 hours on February 26th, yet Detective Tangler did not seize the phone until 1600 hours on February 27th, some 20 hours later. This significant delay undermines any argument that immediate warrantless seizure was, quote, imperative, unquote. They cite McKinney versus Arizona from 1978. If officers genuinely believed emergency access to the phone was necessary, they could have and should have acted much sooner. Even assuming, arguendo, that emergency circumstances initially justified seizing the phone, this would not excuse the failure to obtain a warrant during the subsequent 9.5 hours of possession. The feared medical emergency exception to the warrant requirement permits police to enter and investigate private premises to preserve life or render first aid, provided they do not enter with an accompanying intent either to arrest or search. They cite State versus Foltz from 2016. Detective Tangler's own statements reveal investigatory purpose behind the seizure, as she explicitly told Mr. Stearns, quote, "I told you I was going to hold on to it and that we would like to download your phone, right?" Unquote. Demonstrating from the onset that her intent was to conduct a forensic search rather than address any emergency. Once the phone was secured, any emergency justification for the warrantless seizure dissipated, and officers were required to obtain a warrant for continued possession and examination. Their failure to do so, despite the availability of an emergency duty judge, demonstrates that true emergency circumstances did not exist. Detective Tangler's own actions belie any claim of emergency. After seizing the phone, the detective made no immediate attempt to search it or obtain emergency judicial authorization. Instead, law enforcement simply held it for over 9.5 hours before seeking consent for a forensic examination. This behavior is inconsistent with a true emergency requiring immediate warrantless action to prevent harm. For a warrantless seizure to be justified under the emergency exception, quote, the person making entry must have had an objectively reasonable belief that an emergency existed that required immediate entry to render assistance or prevent harm to persons or property within, unquote. They cite United States versus Moss from 1992. This objectively reasonable belief must be based on specific, articulable facts and reasonable inferences that could have been drawn therefrom. They cite Mora versus City of Gaithersburg from 2008. and also cite Terry versus Ohio from 1968. Here, Detective Tangler failed to articulate any specific facts suggesting why the extended warrantless seizure of the phone was necessary to prevent imminent harm. The extended timeline, failure to pursue available warrant procedures, and law enforcement's own conduct all demonstrate the absence of an objectively reasonable belief in an emergency requiring an immediate warrantless seizure of the phone. Fourth, there were no, quote, community caretaking, quote, circumstances requiring immediate action. They cite Caddy versus Dombrowski from 1973. The phone itself posed no danger to the public, and its seizure was clearly investigatory rather than for community protection purposes. Fifth, there were no exigent circumstances related to officer safety. They cite Maryland versus Bowie from 1990. The phone posted no threat to officer safety, and Mr. Stearns displayed no aggressive or threatening behavior that would justify its immediate seizure. Instead of demonstrating recognized exigency, the record shows that Detective Tangler had ample time and opportunity to obtain a warrant through the Ninth Circuit's established emergency duty judge system under Administrative Order 7-84-11, which has maintained a 24/7 emergency duty judge protocol for nearly 40 years, specifically to handle after-hour warrants. The United States Supreme Court has emphasized that the ability of telephonic warrants is relevant to the exigency analysis. They cite Missouri versus McNeely from 2013. Here, Detective Tangler's complete failure to pursue these readily available warrant procedures during the 9.5-hour seizure, during which Mr. Stearns was completely deprived of his ability to communicate with family members or access any of the phone's essential functions, is particularly erroneous and negates any claim of exigent circumstances. Despite the well-established warrant system and the availability of an emergency duty judge at 1:30 a.m., the detectives deliberately chose not to utilize this source, further demonstrating the unconstitutional nature of their actions. 3. All evidence derived from the unlawful seizure must be suppressed. When consent is obtained after illegal police activity, such as an unauthorized seizure, the unlawful police action presumptively taints and renders involuntary any subsequent consent. They cite Norman versus State and Bailey versus State from 1975. The consent will be held voluntary only if there is clear and convincing proof of an unequivocal break in the chain of illegality sufficient to dissipate the taint of prior official illegal action. The fruit of the poisonous tree doctrine requires suppression of both primary evidence obtained from the initial illegality and secondary evidence derived from the exploitation of that illegality. They cite Wong Sun versus United States from 1963. The relevant inquiry is whether the evidence was obtained by exploitation of the initial illegality or by, quote, means sufficiently distinguishable to be purged from the primary taint, unquote. The Florida Supreme Court has consistently held that evidence discovered by exploiting previous illegal conduct is inadmissible. They cite Craig versus State from 1987. Here, there was no break in the chain of illegality between the unconstitutional seizure and the subsequent searches of the phone. The extended deprivation of Mr. Stearns' phone created coercive circumstances that led to the midnight, quote, consent, unquote, for its forensic examination. Any purported consent was inexplicably intertwined with and the direct product of the illegal seizure. The Google warrant and all derivative evidence were direct products of the initial unlawful seizure, as law enforcement would not have had access to the phone's data without first illegally seizing and retaining it. Therefore, all evidence obtained through exploitation of this unlawful seizure, including the phone's contents, the Google warrant results, and any investigative leads developed therefrom, must be suppressed as fruit of the poisonous tree. Conclusion: Detective Tangler's warrantless seizure of Mr. Stearns' cell phone represents precisely the type of unreasonable government intrusion that the Fourth Amendment was designed to prevent. the 9.5-hour deprivation of an essential communication device without consent or exigent circumstances violated fundamental constitutional principles. All evidence obtained through exploitation of this unlawful seizure must be suppressed to uphold the integrity of the Fourth Amendment and deter future violations. Wherefore, the defendant respectfully requests this honorable court, 1, to set this matter for an evidentiary hearing pursuant to Florida R Criminal Code P. 13.90 subsection H subsection 3. Number 2, suppress all evidence obtained from and derived through the unlawful seizure of his cell phone. And 3, grant such other relief as this court deems just and proper. And it was signed by Melissa Vickers, Public Defender. This document reads, the state of Florida is the plaintiff versus Stephen Michael Stearns as the defendant. It is a motion to suppress evidence obtained from Google search warrant. It reads, comes now the defendant, Stephen Michael Stearns, by and through his undersigned counsel, pursuant to the Fourth Amendment to the United States Constitution, Article 1, Section 12 of the Florida Constitution, and Florida Rule of Criminal Procedure 3.190, subsection G, and hereby moves this honorable court to suppress all evidence obtained directly and indirectly from the execution of a search warrant for his Google account, quote, sustanet@gmail.com, unquote, dated February 28, 2024, and all fruits thereof. As grounds for this motion, the defendant states. Introduction. This motion seeks suppression of all evidence obtained through the execution of a Google account search warrant dated February 28, 2024, as it represents the culmination of a series of deliberate Fourth Amendment violations. The warrant application relied entirely on evidence obtained through prior unconstitutional searches of the defendant's phone, beginning with law enforcement exceeding the scope of limited consent, followed by an unauthorized seizure, and culminating in a coerced midnight download. Rather than establish probable cause through lawful means, detectives relied entirely on evidence obtained through these unconstitutional searches to secure the Google warrant. This warrant application, built solely on the fruits of the constitutional violations and lacking any independent source of probable cause, exemplifies the very type of illegal evidence laundering that the exclusionary rule was designed to prevent. This motion is filed contemporaneously with related motions to suppress evidence obtained from the unlawful search and seizure of Mr. Stearns' phone. Evidence to be suppressed. The defendant moves to suppress the following evidence obtained directly and derivatively from the unlawful search of Google account, quote, sustanet@gmail.com, pursuant to a warrant dated February 28, 2024. 1. All files, photographs, videos, and media contained in the Google Drive folders, including but not limited to over 1,700 files of alleged contraband media spanning from 2019 to 2024, associated metadata, location data, and file creation/modification dates for these files, private messaging data and communication records, cloud storage backup data, and location history and associated information. 2. All subscriber records, Internet Protocol IP logs, location data, and account information obtained from Google in response to the warrant, including but not limited to account creation data, IP address logs, and connection records. Device identifiers and associated hardware information, account passwords, security information, and recovery data, and user profile and account settings data. 3. All fruits of the unlawful Google warrant, including physical evidence seized during subsequent searches based on the Google data, witness statements, and investigative leads derived from Google records, law enforcement reports, analysis, and investigative materials that rely upon the Google data, expert analysis, reports, or testimony based on examination of the Google records. 4. All testimonial evidence and witness statements referencing or incorporating information obtained from the Google account records. Standing. The defendant has standing to challenge these searches under both the Fourth Amendment to the United States Constitution, Article 1, Section 12 of the Florida Constitution, as the owner and holder of the Google account at issue. The United States Supreme Court recognized in Riley v. California that individuals maintain a reasonable expectation of privacy to their digital data, requiring law enforcement to obtain a warrant before searching such information. Riley v. California from 2014 is what they state. The Florida Supreme Court has similarly held that, quote, because a person has a high expectation of privacy in a cell phone's contents, police must then obtain a warrant before intruding into the phone's contents, unquote. They cite Smallwood versus State from 2013, quoting State versus Smith from 2009. This principle has been consistently reaffirmed by Florida courts, which have recognized that, quote, modern technology facilitates the storage of large quantities of information on small portable devices, unquote, and that, quote, the emerging trend is to require a warrant to search these devices, unquote. They cite State versus Worsham from 2017. This constitutional protection extends to cloud storage accounts and digital communications, which often contain even more private data than physical devices. See United States versus Warshik from 2010. Here, as the account holder with a proprietary and processory interest in the password protected data stored in his Google account, Mr. Stearns has standing to challenge these searches. Standard review and basis for evidentiary hearing. When a trial court is called upon to review a magistrate's decision to a search warrant, it must be determined whether substantial evidence supported the magistrate's determination that probable cause existed. This trial court's role is to ensure that the issuing magistrate had a, quote, substantial basis for concluding, quote, that probable cause existed based on the totality of circumstances set forth in the affidavit. They cite Pagan versus State from 2002. An evidentiary hearing is required in this case because the court must determine whether the warrant application contains sufficient untainted evidence to support probable cause after two levels of execution. First, the court must excise all evidence derived from the unconstitutional phone searches to determine whether any independent basis for probable cause remains, ID at 807. Second, the court must excise the affidavit's extensive boilerplate recitations about Google services and law enforcement's conclusory statements to determine whether the remaining case-specific allegations could support probable cause. The law is clear that when improper or tainted evidence is excised, the court must determine whether, quote, the remaining allegations in the affidavit support probable cause. ID, if the excised material was necessary to establish probable cause, the warrant must be voided and the resulting evidence suppressed. Furthermore, the court must determine whether the magistrate could make a, quote, practical common sense decision, whether given all the circumstances set forth in the affidavit, there is a fair probability that contraband or evidence of a crime will be found in a particular case, unquote, citing Illinois versus Gates from 1983. As detailed below, once the tainted evidence and boilerplate language is excised, the remaining content of the affidavit contains only conclusory allegations without specific facts and fails to establish any nexus between the Google account and alleged criminal activity. This determination must be made by examination of the four corners of the affidavit. ID, an evidentiary hearing will allow full development of these fundamental deficiencies in the warrant application presented to the magistrate. Burden on moving party. The defendant moves to suppress the evidence under Florida Rule of Criminal Procedure 3.190 subsection G, subsection 1, subsection B, and subsection D because the Google warrant is insufficient on its face and there was no probable cause for believing the existence of the grounds on which the warrant was issued, as the warrant application relied entirely on prior unconstitutional searches. When challenging the validity of a search warrant, the defendant bears the initial burden of establishing that the warrant is insufficient or lacks probable cause, where, as here, the defendant demonstrates that the warrant application relied on illegally obtained evidence. The burden shifts to the state to prove either that no constitutional violation occurred in obtaining the predicate evidence or that the warrant application contains sufficient untainted evidence to independently establish probable cause. They cite Norman versus State. The state cannot meet this burden as the warrant's probable cause determination rested entirely on conclusory allegations derived from prior unlawful searches without the specific factual descriptions required for a magistrate's independent determination. See State versus McNelia from 2023 and State versus Pelter from 2023. Statement of facts. On February 26, 2024, at approximately 2000 hours, Jennifer Soto reported Madeline Soto missing to the Orange County Sheriff's Office. On February 27th, Detective Francis Hunt identified inconsistencies in statements provided by Ms. Soto and Mr. Stearns. Number 3, Detective Tangler of the Orange County Sheriff's Office was assigned as lead investigator for the missing person investigation. Number 4, on February 27, 2024, at approximately 1600 hours, Detective Tangler, accompanied by Detective Acosta, made contact with Mr. Stearns at his residence. Number 5, the detective's interactions with Mr. Stearns were audio recorded and captured the exchanges between law enforcement and Mr. Stearns. Number 6, Mr. Stearns' residence is located at the address in Kissimmee. Number 7, during this encounter, Detective Tangler sought limited access to Mr. Stearns' cell phone, specifically requesting only to check his Google login status by asking, quote, "Is it okay if I go in your settings real quick? I just want to see if you're logged on to your Google," unquote. Mr. Stearns responded, quote, "Yeah," unquote, to the specific and limited request. 9, despite only receiving consent to, quote, "check if you're logged into your Google," unquote, the detectives conducted an extensive, unauthorized search of Mr. Stearns' cell phone data well beyond this limited scope. Number 10, Mr. Stearns explained that he had recently performed an operating system update, which resulted in an accidental factory reset of his phone, causing him to lose all contacts and information. Number 11, the detectives' questioning and statements to Mr. Stearns indicated they had accessed and reviewed other unspecified data within his phone, all beyond the narrow scope of consent given. Number 12, the detectives used information from this unauthorized search to confront Mr. Stearns about inconsistencies in his timeline and his whereabouts on February 26, 2024. At the conclusion of this interview, Detective Tangler took possession of Mr. Stearns' phone. Then Detective Tangler stated, quote, "I'm going to hold on to your phone," quote, and, quote, "I'll give it back to you when we're done," unquote. At this time, Mr. Stearns expressed concern about maintaining contact with his father through that phone. 16, Detective Tangler dismissed Mr. Stearns' concerns by stating that they could call Ms. Soto's phone instead. Number 17, Mr. Stearns was given no choice regarding the seizure of his phone, nor was any consent sought. Number 18, law enforcement made no attempt to obtain a search warrant for the phone despite having ample time to do so. On February 28th, at approximately 1:30 hours, detectives again made contact with Mr. Stearns. Number 20, the second contact with Mr. Stearns occurred approximately 9 hours and 30 minutes after the initial seizure of his phone. Number 21, during this midnight contact, detectives referenced their earlier unauthorized seizure, stating, quote, "I told you that I was going to hold on to it and that we would like to download your phone, right?" unquote. Number 22, the detectives presented Mr. Stearns with an ultimatum. Quote, "Is this something that I have your consent to do, or do I need to get a search warrant for your phone?" unquote. 23, the detectives pressured Mr. Stearns into providing his PIN by referring back to his prior, quote, "consent," unquote. At this point, Mr. Stearns had only ever consented to letting detectives, quote, "check if you're logged onto your Google," unquote, a limited inspection that should have taken mere seconds to complete. 25, the second, quote, "consent," unquote, for the forensic download was obtained while the phone was already in police possession without lawful authority. The detectives did not present Mr. Stearns with a written consent form for the initial phone search, nor for any other subsequent searches conducted on his personal property. 27, the detectives did not advise Mr. Stearns of his right to refuse consent to search his phone. At approximately 2:40 hours on February 28, 2024, Mr. Stearns' phone was taken into the Orange County Sheriff's Office Digital Forensics Unit. Number 29, the phone was subjected to a comprehensive forensic examination using Cellbrite technology. The Cellbrite forensic extraction allowed detectives to access and examine not only readily available data, but also deleted content, hidden files, system logs, and other digital artifacts not normally accessible to typical users. 31, the detectives accessed and examined personal data unrelated to the current investigation involving the missing person. 32, based on data obtained from these comprehensive digital searches, the investigation was partially transferred to the Kissimmee Police Department due to jurisdictional issues. 33. Detective Tangler noted at this point that the Kissimmee Police Department was advised of the findings from the Cellbrite forensic extraction, and Detective Corporal Illigan and Detective Mark Morris responded to Central Operations Center. During this invasive search, detectives discovered digital evidence that led them to seek additional warrants. 35. One such warrant sought was for Mr. Stern's Google account, sustanet@gmail.com. 36. Deputy Taylor Heller of the Orange County Sheriff's Office sought the warrant for Mr. Stern's Google account on February 28, 2024, the same date as the Cellbrite extraction. 37. In the affidavit for search warrant, Deputy Heller lists his training and experience as follows. Your affiant, Taylor Heller, 9075, is and has been since May 25, 2018, a duly sworn deputy sheriff for the Orange County Sheriff's Office. Your affiant has a bachelor's degree from the University of Central Florida. I have successfully attended Florida Basic Law Enforcement Academy, completed the Orange County Sheriff's Office Basic Recruit Training, and completed the Orange County Sheriff's Office Field Training and Evaluation Program. I'm currently assigned to the Sex Crimes Unit and have investigated numerous adult and juvenile sex crime cases, completed child sex crimes training. I have investigated numerous internet crimes against children cases, training, and continuously complete advanced training in the area. Your affiant has authored arrest warrants and made arrests for the previous mentioned. Your affiant has authored and executed hundreds of search warrants to include residential, vehicle, mobile device, bodily DNA, electronic services, social media, geofencing, historical cell site data, and internet provider. 38. In the affidavit for search warrant, Deputy Taylor Heller referenced the existence of child sexual abuse material, or CSAM, on Stephen Stern's phone through a conclusory statement devoid of specifics as shown below. While investigation, it was discovered, it's redacted, that something to do with Madeline. Stephen Stearns had several files of child sexual abuse material involving Madeline on his cell phone, and the images were stored and, quote, backed up, unquote, to his Google account, quote, sustanet@gmail.com. 39. The affidavit lacks any specificity regarding the purported child sexual abuse material, with no mention of file formats, content descriptions, hash values, or other forensic identifiers. 40. Beyond this one sentence, Deputy Heller's affidavit includes approximately 6 pages of generic, standardized language describing Google's services and data storage capabilities, which appear to be a verbatim template with minimal customization to the specific investigation. 41. The Google warrant application relied on information obtained from the illegal phone search. 42. The Google warrant execution revealed over 1,700 files on a Google Drive folder. These files included photographs, videos, and other media files that formed the basis of this instant case. 44. The files contained associated location data and metadata spanning from 2019 to 2024. All evidence collected in this case, including the Google warrant results and subsequent police investigations, stem directly from the detective's initial illegal search of Mr. Stern's phone on February 27, 2024. Legal argument. All evidence obtained through the Google warrant must be suppressed as fruit of the poisonous tree. The evidence obtained through the Google warrant is the culmination of a series of deliberate constitutional violations by law enforcement, each of which has been separately challenged in concurrently filed motions to suppress. Detectives exceeded the scope of Mr. Stern's initial consent, retained his phone without proper authorization, and conducted a coerced midnight download. They then used the sensitive information extracted from that unconstitutional search, including photos suggesting potential sexual activity, to support their application for the Google warrant. The state cannot justify this warrant under any attenuation or independent source doctrine, as the warrant was built entirely on tainted evidence derived from intentional misconduct. 1. The Google warrant relied entirely on illegally obtained evidence. The affidavit for the Google warrant explicitly references photos obtained during the midnight phone download, describing them as, quote, several files of child sexual abuse material, unquote. These photos, as the direct fruits of an unconstitutional search and seizure, epitomize the, quote, fruit of the poisonous tree, unquote, doctrine articulated in Wong Sun versus United States from 1963. This warrants probable cause. The detectives made no effort to establish an independent source of information or demonstrate any untainted basis for their warrant application. Instead, they relied solely on evidence they had unlawfully extracted from Mr. Stern's phone, a direct violation of the principles set forth in Wong Sun. Additionally, the warrant affidavit failed to disclose the circumstances under which law enforcement obtained possession of Mr. Stern's cell phone. When a warrant is built on the fruits of unconstitutional conduct, suppression of the evidence obtained through the warrant is mandatory to deter law enforcement from benefiting from their violations and to uphold the fundamental protections of the Fourth Amendment. Number 2, no attenuation or intervening circumstances purged the taint. Under Brown versus Illinois from 1975, courts consider several factors to determine whether the taint of prior illegality has been purged. 1. The temporal proximity between the illegality and the acquisition of the evidence. 2. The presence of intervening circumstances. And 3. The purpose and flagrancy of the official misconduct. Here, the violations were temporarily proximate, with the midnight download occurring mere hours before the detectives applied for the Google warrant. The timing demonstrates an unbroken chain of events, where the unlawfully obtained data from the phone was immediately leveraged to craft the warrant application. This chain exemplifies the fruit of the poisonous tree, as there was no attenuation or independent corroboration to purge the taint of the initial illegality. Critically, even after the Orange County Sheriff's Office notified Kissimmee Police Department about their jurisdictional overproportions of the investigation, Orange County detectives proceeded to obtain the Google warrant themselves based solely on the tainted evidence, without allowing the Kissimmee Police Department to conduct any independent investigation. The fact that Orange County maintained control over pursuing the warrant rather than transferring the aspect to Kissimmee Police Department further demonstrates the complete absence of any attenuation or intervening circumstances that could have purged the taint of the initial constitutional violations. There were no intervening circumstances to break the chain of illegality. The warrant relied exclusively on information obtained from the unconstitutional search. The detective's conduct exemplifies purposeful and flagrant misconduct. By systematically expanding the intrusion beyond the scope of Mr. Stern's limited consent, retaining his phone without legal authority, and leveraging coercive threats of a warrant to compel compliance, they exhibited a deliberate disregard for constitutional protections. By seizing Mr. Stern's phone without express authorization and coercing his consent under the threat of a warrant, law enforcement demonstrated a deliberate strategy to erode constitutional safeguards. This flagrancy aligns with the Supreme Court's admonition in Brown that courts must suppress evidence derived as the fruit of deliberate and calculated constitutional violations, ensuring that unlawful actions do not yield admissible evidence. Number 3. The warrant was constitutionally invalid as the fruit of illegal searches. The detectives' use of photos obtained during the improper search and coerced midnight download of Mr. Stern's phone to support Google warrant affidavit highlights the taint infecting the warrant. The affidavit made no effort to minimize the reliance on unconstitutionally obtained evidence, nor did it attempt to establish probable cause independently of the phone data. The warrant is invalid because it was entirely dependent on tainted evidence obtained through unconstitutional searches and seizures. Under the fruit of the poisonous tree doctrine, evidence that is derived from such violations is inadmissible unless the taint is purged, which did not occur here. See Wong Sun versus United States from 1963. The principles underlying Wong Sun and Brown make clear that evidence derived directly from constitutional violations must be suppressed to prevent the exploitation of such misconduct. The evidence obtained through the Google search warrant is inextricably tied to the unconstitutional actions of law enforcement. The detectives' reliance on photos extracted during an illegal search, coupled with their failure to establish an independent basis for probable cause, renders the warrant constitutionally invalid. Suppression of this evidence is the only remedy that preserves the integrity of both the Fourth Amendment and deters future violations of constitutional protections. 2. The warrant application fails to establish probable cause. Even if the court finds the warrant is not fatally tainted by prior constitutional violations, the warrant application independently fails to establish probable cause under both federal and Florida law. The affidavit relies solely on conclusory allegations without the specific factual detail required for digital searches, fails to establish any meaningful nexus between the Google account and alleged criminal activity, and contains insufficient information for a magistrate's independent probable cause determination. A. Legal standard for probable cause in digital search warrants. Under Florida law, a search warrant application must establish 1. That a particular person has committed a crime, the commission element, and 2, that the evidence relevant to the probable criminality is likely located at the place to be searched, the nexus element. See Sanchez versus State from 2014. When reviewing digital search warrants, the magistrate must have sufficient information to make an independent probable cause determination based on the four corners of the affidavit. They cite State versus Pelter from 2023. Quote, sufficient information must be presented to the magistrate to allow that official to determine probable cause. His actions cannot be a mere ratification of bare conclusions of others, unquote. They cite State versus McNeela from 2023, emphasis in original. B. The warrant application contains only conclusory statements without supporting facts. The second district's recent decisions in McNeela and Pelter provide clear guidance on what a digital search warrant affidavit must contain to establish probable cause. In McNeela, law enforcement received a tip from Microsoft through the National Center for Missing and Exploited Children, or NCMEC, that someone had used OneDrive to store child pornography. The affidavit included, quote, detailed descriptions of the four images Microsoft had flagged, unquote, describing them in, quote, graphic detail, alleging that each one depicted a child in a sexually explicit position, unquote. McNeela at 559. The court found this level of detail sufficient because it allowed the magistrate to independently determine whether the images constituted contraband rather than legal content. ID at 562. I mean, I don't know where it's illegal to have any pictures of children in sexual positions, but okay. Similarly, in Peltier, the detective's 14-page affidavit detailed his extensive investigation using BitTorrent to directly obtain dozens of, quote, still and video files, unquote, from the defendant's computer. Peltier at 382. The detective not only provided specific descriptions establishing the illegal nature of the content, but also personally verified the file's contents and included, quote, hash values previously identified as containers of child pornographic images, unquote, ID at 383. The court emphasized that the affidavit furnished, quote, sufficient information to allow the magistrate to conclude that the images constituted child pornography, unquote, precisely because it went beyond mere conclusory statements to provide specific verifiable details about the alleged contraband. The warrant application here consists entirely of conclusory assertions by law enforcement without the specific factual details necessary for the magistrate's independent assessment. Unlike in McNeela, where the affidavit provided, quote, graphic descriptions, unquote, of the alleged contraband, sufficient, quote, for the magistrate to independently determine whether or not they constitute child pornography, unquote, the affidavit here offers only a single conclusory statement that, quote, Madeline's stepfather, Stephen Stearns, had several files of child sexual abuse material involving Madeline on his cell phone, and the images were stored and backed up to his Google account, unquote. The affidavit provides no descriptions whatsoever of any specific files, images, or content that would allow the magistrate to make an independent determination about whether the material actually constituted contraband. While the Peltier affidavit contained detailed factual descriptions allowing, quote, the magistrate to conclude that the images constituted child pornography, unquote, including specific descriptions of dozens of files and hash values previously identified as containing contraband, the affidavit in the present case provides no technical details, no file information, no dates of creation or access, and no factual description of the images and or videos that would enable the magistrate to independently assess whether probable cause existed. Instead, the affidavit merely states in conclusory fashion that, quote, child sexual abuse material, quote, was, quote, discovered, unquote, during the phone search. Exactly the type of, quote, bare conclusion, unquote, that Florida courts have repeatedly rejected as insufficient to establish probable cause under McNeilin and Peltier. C. The warrant application fails to establish a sufficient nexus between the Google account and criminal activity. While the affidavit extensively details general information about how Google services work and what data they may contain, it fails to establish the required nexus between the specific Google account and the alleged criminal activity. See Slayers v. State from 2006, Burnett v. State from 2003, State v. Saborin from 2010. The affidavit contains 6 pages of boilerplate language about Google services generally, but only a single conclusory sentence linking this particular account to any criminal activity, that the images were, quote, backed up, unquote, to the Google account. The affidavit provides no meaningful details to substantiate this claim. There is no explanation for how investigators determined the images were backed up to this specific account, nor when any backup allegedly occurred. The affidavit is silent on what specific Google services were used and whether the account was actively being utilized during the relevant time period. Furthermore, it lacks any subscriber information confirming the defendant's control of the account or providing any login history and access patterns that would demonstrate actual account usage. This failure to establish a clear nexus between the Google account and the alleged criminal activity renders the warrant constitutionally deficient. The warrant application must establish specific facts demonstrating both that a crime occurred and that the evidence of the crime will be found in the place to be searched. See Young v. State from 2024. Here, the affidavit's single conclusory statement about images being, quote, backed up, unquote, to the Google account fails to meet this constitutional requirement. D. The affidavit's reliance on boilerplate language cannot substitute for specific facts. The majority of the affidavit consists of generalized boilerplate language about Google services that could be inserted into any warrant application for any Google account. Such boilerplate recitations cannot substitute for specific facts establishing probable cause. See United States v. Weaver from 1996, finding boilerplate descriptions of law enforcement practices insufficient, and citing in Re. Young from 1983, rejecting FBI affidavit containing, quote, broad boilerplate statements, unquote, describing bail bond operations. They cite United States v. Barham from 1979, praising affidavit's, quote, honest and straightforward recitation, unquote, without artificial boilerplate. Certification denied, 1981, but see United States v. Romo from 1990, holding pre-printed affidavit language irrelevant where probable cause exists. Certification denied, 1991. The affidavit here dedicates barely one paragraph to case-specific facts relating to the Google services while spending 6 pages describing generic features of Google services. This imbalance highlights the absence of actual evidence linking this specific account to criminal activity. When the boilerplate language is set aside, the remaining factual content is insufficient to support probable cause under any standard. E. The warrant's overboard temporal scope lacks probable case support. The warrant itself permits the search of data from January 1st, 2020 to present, yet provides no factual basis for this expansive 4-year time period. The affidavit describes events occurring only in February 2024, but fails to establish any probable cause that evidence of criminal activity would be found in the Google account during the preceding 4 years. See United States v. Weaver from 1996. Warrant application must be supported by specific facts establishing probable cause. The requirement for particularized probable cause is especially critical in the context of digital searches. where courts have recognized heightened privacy expectations. See Riley versus California from 2014 and Young versus State from 2024. The warrant's 4-year temporal scope represents exactly the kind of, quote, general warrant, quote, that the Fourth Amendment was designed to prohibit. Without any factual nexus between the January 2020 start date and the February 2024 events described in the affidavit, the warrant impermissibly authorizes a fishing expedition through years of private digital data. Such overbreadth is particularly concerning given that modern technology, quote, facilitates the storage of large quantities of information, unquote. They cite State versus Worsham from 2017. The warrant's temporal scope must be narrowly tailored to the specific probable cause established in the affidavit, not extended arbitrarily to encompass years of private data without supporting justification. 3. The warrant lacks required particularity for digital searches. The warrant authorizes an impermissibly broad search of virtually all data associated with Mr. Stern's Google account, including all stored communications, location data, associated accounts, and metadata without any meaningful limitations or protocols. The warrant's authorization to search, quote, any and all stored electronic communication or files, unquote, associated with the Google account is precisely the type of general warrant that the Fourth Amendment prohibits. The Supreme Court and Riley emphasized that warrants must be particularly detailed when authorizing searches of digital data, given the immense storage capacity of digital devices and accounts. They cite Riley versus California from 2014. Florida courts have consistently recognized that digital searches require heightened particularity to prevent general rummaging through private data. The 4th District Court of Appeal recently reaffirmed this principle in Young, specifically addressing the heightened privacy expectations in digital data. They cite Young versus State from 2024. As noted in Worsham, modern technology facilitates the storage of vast quantities of private information, making particular search parameters crucial. And they cite State versus Worsham from 2017. Here, rather than specifically describing the evidence sought and limiting the search accordingly, the warrant authorizes law enforcement to search through every conceivable category of digital data. All Google account data, regardless of type or content, all stored communications without temporal or subject matter limitations, all data locations without geographical or temporal restrictions, all associated accounts without establishing their relevance, and all metadata without any limiting parameters. This broad authorization allows exactly the kind of general rummaging through private digital data that the particularity requirement was designed to prevent. The Sixth Circuit and Weaver made clear that warrants must be supported by specific facts, not general authorizations. United States versus Weaver from 1996 is what they cite. The warrant fails to provide any meaningful protocol for searching these vast quantities of private data or any limitations to protect against overboard invasion of privacy. Instead, it operates as a general warrant authorizing law enforcement to search through years of private communications, photos, documents, and sensitive data without appropriate boundaries or restrictions. Conclusion. The evidence in this case was obtained through a calculated series of escalating Fourth Amendment violations, each building upon the last to systematically erode Mr. Stern's constitutional rights. What began with a deceptively narrow request to check Google login settings evolved into an unauthorized seizure of his phone, comprehensive searches of private data, and ultimately the wholesale invasion of his Google account, all without valid consent or proper judicial authorization. The Google warrant represents the culmination of these violations, relying entirely on tainted evidence while failing to establish probable cause through any independent source. The warrant application itself is constitutionally deficient on multiple grounds. It contains only conclusory allegations without the specific factual detail required by McNeela and Peltier, fails to establish any meaningful nexus between the Google account and alleged criminal activity, and relies almost entirely on boilerplate recitations about Google services rather than case-specific facts. Moreover, the warrant's sweeping authorization to search 4 years of private digital data without temporal limitation of appropriate search protocols exemplifies precisely the type of general warrant that the Fourth Amendment was designed to prohibit. Nearly a century ago, Justice Brandeis cautioned against the very type of constitutional compromise we confront today. Decency, security, and liberty alike demand that government officials shall be subjected to the same rules of conduct that are commands to the citizen. Crime is contagious. If the government becomes a lawbreaker, it breeds contempt for law. It invites every man to become a law unto himself. It invites anarchy. To declare that in the administration of criminal law, the ends justify the means, to declare that government may commit crimes in order to secure the conviction of a private criminal would bring terrible retribution. Against that pernicious doctrine, this court should resolutely set its face. That was Olmstead versus United States from 1928. The gravity of the underlying investigation and the intense national media attention it has attracted cannot justify the systematic dismantling of constitutional protections witnessed here. High-profile cases that capture public attention and inflame emotions present the greatest test of our constitutional principles. The Fourth Amendment's protections against unreasonable search and seizures cannot be preserved if law enforcement is permitted to exceed the clear scope of limited consent, exploit unauthorized searches to maintain control of private property, use constitutional violations to establish probate cause for broad intrusions, and launder tainted evidence through the warrant process. The remedy must be complete suppression of all evidence obtained through the Google warrant and all derivative evidence developed through exploitation of these constitutional violations. To hold otherwise would create a blueprint for circumventing constitutional rights through incremental violations, each building toward ever-expanding privacy intrusions. The integrity of the Fourth Amendment requires courts to guard vigilantly against such calculated erosion of fundamental rights. Wherefore, defendant moves this court to suppress all evidence obtained through execution of the Google warrant and all fruits thereof. Respectfully submitted, the public defender, Melissa Vickers. This document is a motion to suppress evidence obtained from unlawful searches of cell phone. It's the state of Florida as the plaintiff versus Stephen Michael Stearns, the defendant. It reads, comes now the defendant, Stephen Michael Stearns, by and through his undersigned counsel, pursuant to the Fourth Amendment to the United States Constitution, Article 1, Section 12 of Florida Constitution, and Florida Rule of Criminal Procedure 3.190G, and hereby moves this honorable court to suppress all evidence obtained directly and indirectly from law enforcement's unlawful searches of his cell phone. As grounds for this motion, the defendant states, Introduction. This case presents two distinct and erroneous violations of Mr. Stearns' Fourth Amendment rights by law enforcement, each flowing from and building upon the other. First, Detective Tangler systematically exceeded the carefully circumscribed scope of Mr. Stearns' limited consent to merely, quote, check if you're logged onto your Google, unquote, instead of conducting a comprehensive search of his private cell phone data, including location history, call logs, and other protected information. Second, law enforcement, already in possession of Mr. Stearns' phone, through their earlier overreach, orchestrated a coercive late-night confrontation to extract, quote, consent, unquote, for a complete forensic download of his device. This motion is filed contemporaneously with related motions to suppress evidence obtained from the unlawful seizure of Mr. Stearns' phone and evidence obtained through the subsequent Google account warrant that relied on the fruits of these unconstitutional searches. Evidence to be suppressed. Any and all tangible or intangible evidence obtained contemporaneous to and following the illegal searches of Stephen Michael Stearns' cell phone on February 27 through the 28th, 2024, specifically including but not limited to 1. All data obtained during the initial unauthorized search that exceeded the scope of Mr. Stearns' limited consent, including but not limited to location data, call logs, text messages, browsing history, photographs, videos, and any other digital content accessed beyond checking Google login status. 2. All evidence obtained through the Cellbrite forensic extraction of Mr. Stern's phone, including but not limited to extracted photographs and videos, text messages and communication records, location data and GPS coordinates, call logs and contact information, application data and usage information, deleted content recovered through forensic extraction, file metadata and system logs, and any other digital evidence obtained through the Cellbrite process. 3. All derivative evidence and investigative leads developed through exploitation of these unlawful searches, including but not limited to physical evidence discovered using information from the phone, witness statements obtained through information learned from the phone, search warrants predicated on information from these searches, evidence obtained through the execution of such derivative warrants, and any other evidence that would not have been discovered but for these unconstitutional searches. 4. All law enforcement observations, reports, analysis, testimony, and other evidence concerning the contents of the phone, results of the forensic examination, or investigative steps taken based on information obtained from these illegal searches. Standing. Stephen Michael Stearns has standing under the Fourth Amendment to the United States Constitution and Article 1, Section 12 of the Florida Constitution, as he was the owner and processor of the cell phone that was illegally searched. Riley v. California establishes that cell phones are entitled to heightened Fourth Amendment protection due to the vast amount of private information they contain. And they again cite Riley v. California from 2014. Burden on the moving party. The moving party's initial burden has been met through documented evidence of warrantless searches in law enforcement reports. Once established that searches occurred without warrants, the burden shifts to the state to prove an exception applies. They cite Norman versus State from 1980. While the state may argue consent, they must prove both the initial consent was freely given and that the subsequent searches remained within the scope of that consent. They cite United States versus Blake from 1989. Statement of facts. 1. On February 26, 2024, at approximately 2000 hours, Jennifer Soto reported Madeline Soto missing to the Orange County Sheriff's Office. 2. On February 27, 2024, Detective Francis Hunt identified inconsistencies in statements provided by Ms. Soto and Mr. Stearns. 3. Detective Tangler of Orange County Sheriff's Office was assigned as lead investigator. 4. On February 27th at approximately 1600 hours, Detective Tangler, accompanied by Detective Acosta, made contact with Mr. Stearns at his residence. 5. The detective's interaction with Mr. Stearns were audio recorded and captured on the exchanges between law enforcement and Mr. Stearns. Mr. Stearns' residence is located at Number 7. During this encounter, Detective Tangler sought limited access to Mr. Stearns' cell phone, specifically requesting only to check Google login status by asking, quote, "Is it okay if I go into your settings real quick? I just want to see if you're logged on to your Google," unquote. 8. Mr. Stearns responded, quote, "Yeah," quote, to this specific and limited request. 9. Despite only receiving consent to, quote, "check if you're logged on to Google," the detectives conducted an extensive unauthorized search of Mr. Stearns' cell phone data well beyond the limited scope. 10. During subsequent questioning, the detectives revealed their unauthorized intrusion by confronting Mr. Stearns with specific details about his movements and activities with information that could only have been obtained from searching his Google Maps location history on his cell phone. 11. The detectives further demonstrated their unauthorized access by directing pointed questions to Mr. Stearns about specific calls and communications that could only have been discovered through an exploration of his phone's call logs and messaging data. 12. Detective Tangler specifically stated, quote, "I was checking your call history. I noticed that you don't have anything before this morning. Is that unusual on your phone?" Quote, unquote. 13. Mr. Stearns explained that he had recently performed an operating system update which resulted in an accidental factory reset of his phone, causing him to lose all contacts and information. 14. The detectives' questioning and statements to Mr. Stearns indicated that they had accessed and reviewed other unspecified data within his phone, all beyond the narrow scope of consent given. 15. The detectives used information from this unauthorized search to confront Mr. Stearns about inconsistencies in his timeline and about his whereabouts on February 26, 2024. 16. At the conclusion of the interview, Detective Tangler took possession of Mr. Stern's phone. 17. Then Detective Tangler stated, quote, "I'm going to hold on to your phone," unquote, and, quote, "I'll give it back to you when we're done," unquote. 18. At this time, Mr. Stearns expressed concern about maintaining contact with his father through that phone. 19. Detective Tangler dismissed Mr. Stearns' concerns by stating that they could call Ms. Soto's phone instead. 20. Mr. Stearns was given no choice regarding the seizure of his phone, nor was any consent sought. 21. Law enforcement made no attempt to obtain a search warrant for the phone, despite having ample time to do so. 22. On February 28, 2024, at approximately 1:30, detectives again made contact with Mr. Stearns. 23. The second contact with Mr. Stearns occurred approximately 9 hours and 30 minutes after the initial seizure of his phone. 24. During this midnight contact, detectives referenced their earlier unauthorized seizure, stating, quote, "I told you I was going to hold on to it and that we would like to download your phone, right?" unquote. 25. The detectives presented Mr. Stearns with an ultimatum. Quote, "Is this something I have your consent to do, or do I need to get a search warrant for your phone?" 26. The detectives pressured Mr. Stearns into providing his PIN, referring back to his prior, quote, "consent," unquote. 27. At this point, Mr. Stearns had only ever consented to letting detectives, quote, "check if you're logged onto your Google," unquote, a limited inspection that should have taken mere seconds to complete. 28. The second, quote, "consent," unquote, for the forensic download was obtained while the phone was already in police possession without lawful authority. 29. The detectives did not present Mr. Stearns with a written consent form for the initial phone search, nor for any other subsequent searches conducted on his person or property. 30. The detectives did not advise Mr. Stearns of his right to refuse consent to search his phone. 31. The detectives did not provide Mr. Stearns with any documentation regarding the seizure of his phone. 32. The detectives did not document any exigent circumstances justifying the warrantless seizure. 33. During the initial round of questioning, Detective Tangler noted that Mr. Stearns stated he had taken an Ativan earlier that night for panic attacks. He explained that he had not needed the tranquilizers for some time, but had taken them to help him sleep. 34. Ativan is a prescription sedative commonly used to treat anxiety and panic disorders known to cause drowsiness, sedation, and impaired alertness. 35. Mr. Stearns described these effects of Ativan to law enforcement, stating, quote, "This is why I missed your calls. I'm sorry, took an Ativan and conked out for a few hours," unquote. 36. At the time of this midnight interaction, Mr. Stearns had been detained outside in 50 to 60 degree temperatures, wearing only flip-flops, khaki pants, and a thin hoodie. He had not eaten all day and was prevented from returning to Ms. Soto's heated vehicle after initial questioning. 37. At approximately 2:40 hours on February 28, 2024, Mr. Stearns' phone was taken to the Orange County Sheriff's Digital Forensics Unit. 38. The phone was subjected to a comprehensive forensic examination using Cellbrite technology. 39. The Cellbrite forensic extraction allowed detectives to access and examine not only readily available data, but also deleted content, hidden files, system logs, and other digital artifacts not normally accessible to typical users. 40. The detectives accessed and examined personal data unrelated to the current investigation. 41. Based on the data obtained from these comprehensive digital searches, the investigation was partially transferred to Kissimmee Police Department due to jurisdictional issues. 42. Detective Tangler noted at this point that the Kissimmee Police Department was advised of the findings from the Cellbrite forensic extraction, and Detective Corporal Illigan and Detective Mark Morris responded to Central Operations Center. 43. During this invasive search, detectives discovered digital evidence that led them to seek additional warrants. 44. One such warrant sought was from Mr. Stearns' Google account, sustanet@gmail.com. 45. The Deputy Taylor Heller of the Orange County Sheriff's Office sought the warrant for Mr. Stearns' Google account on February 28, 2024, the same day as the Cellbrite extraction. 46. The Google warrant application relied on information obtained from the illegal phone search. 47. The Google warrant execution revealed over 1,700 files on a Google Drive folder. 48. These files included photographs, videos, and other media files that form the basis of this instant case. 49. The files contained associated location data and metadata spanning from 2019 to 2024. 50. All evidence collected in this case, including the Google warrant results and subsequent police investigations, stem directly from the detective's initial illegal search of Mr. Stern's phone on February 27, 2024. 51. Neither detectives from the Orange County Sheriff's Office nor those from the Kissimmee Police Department sought a warrant to search the contents of Mr. Stern's phone. Legal argument. A. The initial search of the defendant's phone exceeded the scope of his limited consent. Law enforcement's actions in this case present a textbook example of how officers can systematically erode Fourth Amendment protections by exploiting a citizen's limited consent. Detective Tangler's transformation of narrow permission to, quote, check Google login status, unquote, into a comprehensive search of Mr. Stern's private cell phone data epitomizes the type of incremental overreach that occurs that courts have consistently rejected, particularly in the context of modern digital devices that contain the most intimate details of a person's life. 1. The constitutional framework for consensual searches. The scope of consensual search is limited by the actual consent given. As the Florida Supreme Court established in Norman, warrantless searches are, quote, per se unreasonable under the Fourth Amendment, subject only to a few specifically established and well-delineated exceptions, unquote. They cite Norman. They cite Katz versus United States from 1967. These exceptions are, quote, jealously and carefully drawn, unquote, citing Jones versus United States from 1958. The burden is upon the state to demonstrate that obtaining a warrant was not feasible because, quote, the exigencies of the situation made that course imperative, unquote, citing McDonald versus United States from 1948. While consent is one such exception, the state has the burden of proving that consent was freely and voluntarily given. That's important, freely and voluntarily given. Citing Schoenhoff versus Bustamante from 1973 and Bumper versus North Carolina from 1968. In Florida specifically, the prosecution must show by clear and convincing evidence that the defendant freely and voluntarily consented to the search. Citing Bailey versus State from 1975, Saganois versus State from 1956. In Florida versus Gimeno from 1991, the United States Supreme Court established that the standing for measuring the scope of consent is, quote, objective reliableness, unquote, i.e., what a typical reasonable person would have understood from the exchange between the officer and the subject. A suspect retains the ability to define the scope of any consent given. In Walter versus United States, the United States Supreme Court held that consent to search does not equate to unlimited permission. Walter versus United States from 1980 is what they cite. When an officer receives limited consent for a specific purpose, they may not exceed that limitation. United States versus Millen Rodriguez from 1985 is what they cite. Most critically, for the case at bar, when consent is obtained after illegal police activity such as an unauthorized search or arrest, the unlawful police action presumptively taints and renders involuntary any consent to search. Citing Bailey versus State, Ehrman versus State from 1972, see also Brown versus Illinois from 1975, Wong-Sun versus United States from 1963. The consent will be held voluntary only if there is clear and convincing proof of an unequivocal break in the chain of illegality sufficient to dissipate the taint of prior official illegal action, citing Bailey versus State and Sheff versus State from 1976. Number 2, cell phones required enhanced privacy protection under Riley. The United States Supreme Court landmark decision in Riley versus California established that cell phones require heightened constitutional protection given their unique ability to store vast quantities of intensely personal information. Riley from 2014 is what they cite. As the court emphasized, modern cell phones are, quote, now a pervasive and insistent part of daily life, unquote, that contain, quote, the privacies of life, unquote, from intimate photos and messages to detailed records of a person's movements, associations, and private interests. As the Riley court noted, even the most popular smartphone at the time of the opinion contained 16 gigabytes of storage, enough to hold, quote, millions of pages of text, thousands of pictures, or hundreds of videos, quote. Today's phones, with storage capacities often exceeding 256 gigabytes, can hold exponentially more private data, making Riley's privacy concerns even more acute. Because phones collect and store such comprehensive data about every aspect of a person's life, law enforcement searches of these devices raise profound privacy concerns that demand robust Fourth Amendment protection. This is particularly true when officers exceed the scope of limited consent, as Detective Tangler did here. By accessing location data, call logs, and other private information after obtaining permission only to check login status, Detective Tangler conducted precisely the type of invasive search that Riley sought to protect against. One that revealed, quote, the sum of an individual's private life, unquote, without proper authorization. The detective's actions perfectly illustrate why the United States Supreme Court emphasized that cell phones are, quote, not just another technological convenience, unquote, but rather contain the very, quote, privacies of life, unquote, that founders sought to protect from unreasonable government intrusion. Number 3, detectives systematically exceeded consent to conduct unlawful search. The facts here present a clear case of law enforcement exceeding the scope of limited consent. The exchange between Detective Tangler and Mr. Stearns was unambiguous, explicit, and unequivocal. The detective specifically asked, quote, is it okay if I go in your settings real quick? I just want to see if you're logged on to your Google, unquote. Mr. Stearns responded with a simple, quote, yeah, to this carefully circumscribed request. No reasonable person would understand this exchange as granting permission for a comprehensive search through their phone's contents. See Florida versus Gimeno from 1991. Scope of consent measured by, quote, objective reasonableness, unquote, i.e., what would the typical reasonable person have understood from the exchange. Yet, Detective Tangler immediately began conducting a broad search far beyond this limited authorization. The detective scrolled through various applications examining Google Maps, history, call logs, and other private information never contemplated by the narrow request and subsequent consent to check login status. Federal courts have consistently held that such expansion beyond the scope of consent renders a search unconstitutional. The First Circuit held that consent to search an apartment did not authorize the search of a personal computer found within. They cite United States versus Turner from 1999. Similarly, when police exceed the scope of consent by searching personal papers after representing that they would only look for narcotics, such conduct was unconstitutional, as government agents may not obtain consent to search on the representation that they intend to look only for certain specified items and subsequently use that consent as a license to conduct a general exploratory search. They cite United States versus Disarante from 1971. The detective's subsequent conduct demonstrates her violations of these constitutional limits. Having accessed data the detective was never authorized to view, she began interrogating Mr. Stearns about his call history and travel patterns, using improperly obtained private information to challenge his statements. This matches patterns courts could have identified as exceeding the scope of consent. See ID at 129 through 30. Her deliberate use of improperly obtained data reveals that this was not an inadvertent overstep, but rather a calculated design to ignore the clear limitations of Mr. Stearns' consent. Detective Tangler's progression from checking settings to searching private data represents a deliberate breach of the consent's boundaries. Her transformation of limited protection to, quote, check Google login status, unquote, into a comprehensive search of Mr. Stern's entire phone exemplifies the type of overreach courts have consequently rejected. Detective Tangler's own interrogation revealed this violation. As she confronted Mr. Stearns with private data she knew was beyond the permission granted. When consent creates a boundary, law enforcement cannot ignore it. Number 4. The state cannot satisfy Florida's consent requirements because the search exceeded all boundaries of the established consent. The state bears the burden of establishing both that consent was freely given and that the search remained within its scope. They cite Norman from 1980. Given the Florida Supreme Court's clear directive that cell phones require heightened privacy protection, this burden is particularly heavy when officers exceed the scope of consent to search these devices. The state bears a heightened burden in establishing the validity of this search given the unique privacy interest at stake. Under Florida law, when a motion to suppress an illegal search is filed, the initial burden is on the defense to show a warrantless search occurred and was presumptively invalid. They cite Miles v. State from 2007. The burden is clearly met here through law enforcement's own reports documenting their warrantless searches of Mr. Stern's phone. The burden thus shifts to the state to prove an exemption applies, in this case, consent. However, the state must prove both that initial consent was freely given and that officers strictly adhered to its scope. They cite United States v. Blake from 1989. This is a particularly demanding burden when dealing with cell phones, which the United States Supreme Court has recognized contain, quote, the privacies of life, unquote, requiring robust constitutional protection. They cite Riley from 2014. The state cannot meet this burden. The record shows Detective Tangler received one narrowly defined permission to, quote, check if you're logged onto your Google, unquote, in the phone settings. No subsequent consent was ever obtained to search call logs, location data, messages, photos, or any other private data on Mr. Stern's phone. Yet, Detective Tangler deliberately exceeded these clear boundaries, accessing and exploring private information far beyond the settings menu. This mirrors the precise type of overreach Florida courts have consistently rejected. Just as consent to look in a vehicle's trunk does not authorize prying open locked luggage found inside, permission to check login status cannot justify a wholesale invasion of private phone data. See State v. Wells from 1989. Detective Tangler's progression from checking settings to searching private data shows an unambiguous breach of the only consent Mr. Stearns was provided. Most damaging to the state's position are Detective Tangler's own statements demonstrating her knowing and intentional violation of the scope of consent by declaring, quote, I was checking your call history, unquote, and confronting Mr. Stearns with location data from Google Maps. Detective Tangler herself documented that she deliberately ventured far beyond merely checking login status. Detective Tangler's own words provide direct evidence that she knowingly exceeded the narrow scope of consent, transforming what should have been a quick settings check into an invasive search of private data. The detective's candid admission of searching call logs and location data, neither of which could conceivably be necessary to verify Google login status, revealed this was not an inadvertent expansion of the search, but rather a deliberate choice to ignore constitutional boundaries. The state cannot articulate any legitimate investigative necessity that required Detective Tangler to exceed the narrow scope of consent. Detective Tangler had multiple constitutional options available. She could have sought expanded consent, obtained a warrant, or simply confined her search to the limited permission granted. Instead, the detective made the calculated decision to exploit Mr. Stern's limited consent as a gateway to conduct a comprehensive search of his private data. This type of scope violation is precisely what courts have sought to deter through suppression. B. The subsequent, quote, consent, unquote, to download the phone was involuntary under the totality of circumstances. The evidence in this case underscores how law enforcement's tactics crossed constitutional boundaries to secure purported, quote, consent, unquote, for a comprehensive search. Detectives systematically eroded Mr. Stern's rights by exceeding limited permissions, exploiting the prolonged seizure of his phone, and wielding coercive threats to compel compliance. These actions demonstrate a deliberate strategy to bypass constitutional safeguards, rendering any alleged consent involuntary and invalid under the Fourth Amendment. The state cannot meet its burden of proving that Mr. Stern's consent to have his cell phone forensically examined was freely and voluntarily given, as required by established precedent, due to the pervasive misconduct and coercion employed by law enforcement. 1. Consent following illegal police actions is presumed involuntary. Consent obtained following illegal police activity such as an unauthorized search or seizure is presumed involuntary. Under Norman, the presumption of taint applies unless there is clear and convincing proof of an unequivocal break in the chain of illegality sufficient to dissipate the prior misconduct. They cite Norman from Florida, 1980. The state bears the burden of proving such a break, and without this proof, the consent remains invalid. This principle underscores the requirement that voluntariness must be free from coercive circumstances arising from prior unlawful conduct. Under Schekenkloth versus Bustamante, voluntariness necessitates a free and unconstrained decision-making process, a standard that ensures constitutional protections remain robust against coercive practices. And Schekenkloth versus Bustamante from 1973 is what they cite. The Fourth Amendment's prohibition against unreasonable searches requires that consent be, quote, freely and voluntarily given, unquote. Voluntariness is determined by examining the, quote, totality of all the circumstances, unquote, a nuanced analysis that precludes reliance on superficial assurances. 27. The state carries the burden of providing voluntary consent by clear and convincing evidence. Florida courts also require adherence to these standards under Article 1, Section 12 of the Florida Constitution, which mandates conformity with the United States Supreme Court precedent. Court assesses voluntariness through various factors, including but not limited to 1. The timing and location of the interaction. 2. The number of officers involved. 3. The officer's conduct and language. 4. The defendant's age, intelligence, and education. 5. The defendant's physical and mental state. 6. Whether the defendant was informed of their constitutional rights. And 7. Whether the interaction became adversarial. See Ramirez-Chintel versus State from 2002 and Schekenkloth. Of particular importance, prior police misconduct can validate subsequent consent. See Wong-Sun versus United States from 1963, Bumper versus North Carolina from 1968, holding that mere acquiescence to a claim of lawful authority does not constitute valid consent. 2. Detectives' initial misconduct rendered subsequent consent invalid. The initial interaction in which Mr. Stearns temporarily surrendered his phone to law enforcement exemplifies how prior constitutional violations can render subsequent consent invalid. As previously discussed, detectives exploited Mr. Stearns' limited authorization to, quote, check his Google login status, unquote, by immediately delving into his Google map history, call logs, text message records, and stored photos, an overreach that flagrantly violated the narrow scope of consent. When confronted about the lack of call history on his phone, Mr. Stearns explained that he had recently performed an operating system update, which resulted in the accidental factory reset, causing him to lose his contacts and information. Despite this explanation for the phone's condition, detectives continued their unauthorized search and subsequent seizure of the device, demonstrating their intent to conduct a more invasive forensic examination regardless of the information readily available on the device. The detectives' disregard for the clearly defined parameters of consent was not merely a technical violation, but rather the first step in a calculated strategy to circumvent Fourth Amendment protections. By immediately exceeding the boundaries of permission, They demonstrated a pattern of misconduct that would persist throughout their interactions with Mr. Stearns. The detectives' willingness to ignore express limitations on their authority created an atmosphere where Mr. Stearns could reasonably conclude that any attempt to assert his rights would be similarly disregarded. Number 3, law enforcement's tactics demonstrated coercion when detectives seized Mr. Stearns' cell phone. Following the unauthorized search, Detective Tangler unilaterally announced, quote, "I am going to hold on to your phone," unquote, and refused to return it until the investigation concluded. At no point did law enforcement request permission for this seizure, nor did they clarify Mr. Stearns' rights to object. Her declaration, coupled with her earlier disregard for the boundaries of consent, left no doubt that law enforcement would exert complete dominion over the device, irrespective of Mr. Stearns' wishes. This violation of established boundaries stripped Mr. Stearns of his legitimate expectation of privacy and tainted any subsequent interactions. Law enforcement's actions must be understood within the broader context of coercion, as outlined in Sheckencloth versus Bustamante, which emphasizes that voluntariness must be examined on a totality of circumstances basis. Here, the detectives' overreach in expanding the scope of consent, coupled with their refusal to return the phone and threats to obtain a warrant, aligns closely with judicial principles recognizing the invalidity of consent obtained through pressure or implied authority. The systematic erosion of autonomy underscores the constitutional violation at issue here. By exceeding the initial consentence boundaries and seizing the phone without justification, the detectives made it unambiguously clear that Mr. Stearns' expressed boundaries and concerns were meaningless in their pursuit of unfettered access to his cell phone. This conduct again allies with judicial principles articulated in Sheckencloth versus Bustamante, emphasizing that voluntariness requires a free and unconstrained decision-making process. The detectives' actions, marked by overreach and unilateral authority, directly contravened these principles, creating an environment where any perceived consent was the product of coercion rather than informed agreement. When Mr. Stearns voiced concerns about his inability to communicate with his father, detectives dismissed these objections. Their dismissive response, implying that alternative arguments could suffice, trivialized Mr. Stearns' valid concerns and reinforced a sense of helplessness and demonstrated the detectives' complete control over the situation. Their actions made clear that Mr. Stearns had no real choice but to acquiesce to their authority, as they had already shown that they would exercise dominion over his property regardless of his wishes or rights. Such coercive conditions align with the principle that mere submission to authority cannot constitute valid consent. They cite Bumper versus North Carolina from 1968. Here, the detectives' disregard for Mr. Stearns' objections and failure to articulate clear boundaries amounted to a systematic imposition of their authority. These tactics eroded any semblance of voluntariness, leaving Mr. Stearns in a state compliance was perceived as his only viable option. The totality of circumstances shows that Mr. Stearns' actions constituted mere acquiescence to an overwhelming display of police authority rather than a product of free and voluntary choice. Number 4, law enforcement's coercion reached its peak with the midnight download request. Finally, detectives compounded their misconduct by employing the type of inherently coercive tactics explicitly condemned by Florida courts and Butler, by suggesting that if the defendant did not, quote, voluntarily, unquote, consent to a complete forensic download of his cell phone, they would simply obtain a warrant. They cite Butler versus State from 1997. The Second District has made clear that such implied threats to obtain a warrant invalidate purported voluntary consent. Rather than simply obtaining a warrant for the cell phone itself or its contents, which according to Riley versus California can be accomplished electronically in, quote, less than 15 minutes, unquote, detectives chose to orchestrate a coercive late-night confrontation to pressure Mr. Stearns into consenting to a phone download at approximately 1:30 a.m. This choice is particularly erroneous given that Ninth Judicial Circuit Administrative Order 78411 has long established a clear protocol in the Ninth Circuit for obtaining emergency warrants at any hour. For nearly 40 years, this circuit has maintained an emergency duty judge system specifically designed to handle after-hours warrants and other emergency matters, with a judge available 24/7 to review and sign warrants. Despite this well-established system and the ready availability of an emergency duty judge at 1:30 a.m., the detectives deliberately chose not to utilize this resource. The detectives' calculated choice to avoid these readily available warrant procedures in favor of extracting, quote, consent, unquote, through coercive tactics at midnight demonstrates this was not about investigative necessity, but rather a deliberate strategy to circumvent constitutional requirements. Stop it. Stop it. This intentional avoidance of available judicial oversight is precisely the type of conduct that the Fourth Amendment's warrant requirement was designed to prevent. By this point, at this incredibly late hour, detectives had established a clear pattern. They had disregarded the limitations of Mr. Stern's consent, retained unauthorized physical control of his phone, and dismissed his attempts to assert his rights. During this interaction, Detective Tangler presented Mr. Stearns with a Hobson's choice, stating, quote, "You can consent to the download now or we'll just get a warrant," unquote. A tactic designed to create the illusion of choice while pressuring him into compliance. Under these circumstances, the so-called, quote, choice, unquote, presented to Mr. Stearns, consent to the download or await a warrant, was entirely illusory, particularly since the detectives were already in unlawful possession of his phone. As in Butler, where police explicitly threatened to obtain a warrant unless consent was given. Such coercive tactics render any consent invalid. They cite Butler. By exploiting their unauthorized possession of the phone and presenting the warrant as inevitable, the detectives left Mr. Stearns with no meaningful choice but to comply. Courts have invalidated similar scenarios where purported consent is coerced by leveraging threats of inevitable legal actions, as in Florida versus Royer from 1983. In Royer, the United States Supreme Court held that law enforcement's conduct in that case, detaining an individual without clear justification and creating an environment where compliance appeared mandatory, vitiated consent. ID, here the detectives employed a calculated strategy of systematic overreach and demonstrated repeated disregard for constitutional boundaries by establishing a pattern of bypassing legal protocols and dismissing Mr. Stearns' attempts to assert his rights. The detectives created circumstances where any illusion of choice was merely a facade. Their demonstrated willingness to exceed legal limitations left Mr. Stearns with no meaningful opportunity to protect his privacy interest regarding his subsequent acquiescence involuntarily under established Fourth Amendment principles. 5. Coercive circumstances nullified voluntary consent. Critically, the detectives' failure to acknowledge or remedy their earlier misconduct underscores the invalidity of the midnight request. The taint from the first unauthorized seizure and search of Mr. Stearns' phone had not been dissipated as required under Norman. The detectives' explicit mention of a potential warrant without advising Mr. Stearns of his right to refuse consent further cemented the coerced nature of the interaction as noted in Butler. By disregarding the limits of Mr. Stearns' initial consent and seizing his phone without proper authorization, they created an environment where their access to the phone's data appeared inevitable. As the Florida Supreme Court held in Montes Velatin versus State, where there is an illegal detention or other illegal conduct by police, quote, consent will be found voluntary only if there is clear and convincing evidence that the consent was not a product of the illegal police action, unquote. They cite Montes Velatin versus State, again from 2017. No such evidence exists here, where the detectives' coercive tactics flowed directly from their pattern of misconduct, exceeding the scope of initial consent by conducting an unauthorized search of the phone's contents, unilaterally seizing and retaining the phone without legal authority, exploiting information improperly obtained during that unauthorized search to pressure Mr. Stearns, and then leveraging their wrongful possession of the phone in the middle of the night to extract, quote, consent, unquote, for a complete download. The Fourth Amendment's protections hinge on ensuring that content is, quote, the product of an essentially free and unconstrained choice, unquote. They cite Schekenkloth versus Bustamante from 1973. Here, the totality of circumstances established by Ramirez, Chile, and Schekenkloth overwhelmingly demonstrates that Mr. Stearns' purported consent was anything but voluntary. Under Ramirez, Chile, courts evaluate voluntariness by considering multiple factors. First, the timing and location of the interaction underscore its inherently coercive nature. Detectives confronted Mr. Stearns at his residence at 1:30 a.m., forcing him to stand outside in the cold without permitting him to return to his home or vehicle for warmth. The interaction, which could have easily been conducted during normal business hours, was entirely unnecessary, particularly given that law enforcement already knew the phone had been factory reset and that no exigency existed. Second, the intimidating presence of multiple detectives further compounded the coercive atmosphere. By stationing several officers at the scene and refusing to provide Mr. Stearns with basic comforts, law enforcement created an environment designed to overbear his will. Third, the detective's conduct and language displayed a dismissive disregard for Mr. Stearns' objections and concerns. Despite his expressed need to communicate with his father and his clear attempts to limit the scope of their access, the detectives instead exploited the situation. Their use of Hobson's choice, quote, consent on the download now, or we'll just get a warrant, unquote, was a calculated tactic to compel compliance under the guise of voluntariness. Fourth, while Mr. Stearns is an adult, he lacked the specialized knowledge to necessarily navigate the complex constitutional implications of his consent. His limited experience with the legal system, having only one prior arrest, which was ultimately nolle prosequi, left him particularly vulnerable to coercive tactics. Fifth, Mr. Stearns' physical and mental state was significantly compromised. He had been detained outside in cold temperatures for hours without food, was emotionally distraught about the ongoing investigation, and was under the influence of Ativan, a prescription tranquilizer known to impair alertness and judgment. Sixth, the detectives failed to inform Mr. Stearns of his constitutional right to refuse consent or insist on a warrant. Law enforcement officers are not only expected, but required to adhere to constitutional principles, including those governing voluntary consent. Finally, the interaction became overtly adversarial when detectives retained possession of Mr. Stearns' phone and presented him with the ultimatum, quote, consent on the download now or we'll just get a warrant, unquote. By continuing to unlawfully hold his phone, law enforcement rendered Mr. Stearns powerless and effectively stripped him of any real ability to refuse. Under these circumstances, every factor outlined in Ramirez-Chilel points to one conclusion. The state cannot meet its burden of proving by clear and convincing evidence that Mr. Stearns' purported consent was the product of free and voluntary choice. The detectives' efforts to compel compliance were not only unconstitutional, but also entirely unnecessary. As the United States Supreme Court aptly declared in Riley versus California, quote, what police must do before searching a cell phone is simple, get a warrant, unquote. They cite Riley from 2014. Instead of systematically wearing down Mr. Stearns into compliance and leveraging threats of a warrant, law enforcement could have easily avoided this constitutional violation by simply obtaining one. Law enforcement had multiple opportunities to seek a warrant, but deliberately chose not to. From the onset, they had the ability to pursue a warrant and could have done so at the point of the initial non-consensual seizure. Additionally, they had ample time to obtain a warrant while the phone remained in their custody, entirely removed from Mr. Stearns' control, at any point thereafter. Despite these ample opportunities, they instead chose to circumvent constitutional safeguards, relying on coercion and improper tactics to gain access to the cell phone's contents. The totality of circumstances surrounding the Cellbrite download, quote, consent, unquote, reveals a calculated strategy to circumvent constitutional requirements through a combination of unlawful seizure, coercive tactics, and exploitation of Mr. Stern's vulnerable state. The 9.5-hour warrantless seizure, the orchestrated midnight confrontation while Mr. Stearns was impaired by Ativan and subjected to physical discomfort, the ultimatum about obtaining a warrant, and the deliberate avoidance of available warrant procedures all demonstrate that any, quote, consent, unquote, was the product of coercion rather than free choice. We, as here, law enforcement systematically creates circumstances designed to compel compliance rather than facilitate genuine voluntary choice. Suppression is required. Conclusion. Law enforcement's conduct in this case represents a flagrant disregard for the Fourth Amendment and well-established legal principles governing search and seizures. Detective Tangler's unauthorized expansion of the limited consent given by Mr. Stearns, the prolonged warrantless seizure of the phone, the coercive tactics employed to extract, quote, consent, unquote, for a forensic download collectively demonstrate an erroneous violation of constitutional protections. Under the totality of circumstances, Mr. Stearns' purported consent was the product of coercion rather than voluntarily knowing and intelligent waiver of his rights. The detective's repeated overreach, first by exceeding the narrow scope of consent, then by unlawfully seizing and retaining the phone, and finally by leveraging its possession to coerce a forensic download under the threat of a warrant, renders all evidence obtained through these actions inadmissible. To uphold the integrity of the judicial system and safeguard against future unlawful searches, suppression is not merely appropriate, it is required, given the deliberate and repeated constitutional violations in this case. Suppression is the only remedy that restores Mr. Stearns' constitutional rights and deters future misconduct by law enforcement, which flagrantly disregarded established Fourth Amendment safeguards. Wherefore, the defendant respectfully requests this honorable court, 1, to set this matter for an evidentiary hearing pursuant to Florida Rule Criminal Code P.3.190, subsection H, subsection 3, and subsection 2, suppress all evidence obtained from and derived through the unlawful searches of his cell phone, including but not limited to the Cellbrite forensic extraction and the subsequently obtained Google account warrant, and 3, grant such other relief as the court deems just and proper. Respectfully submitted by Melissa Vickers. I want to thank you all for watching this video to the end. I really appreciate it. I know it's been a long one. These documents are important. They could change the whole outcome of the CSAM trial. Please let me know what you think in the comments section below. Thank you so much and have a good day.